Hello. Once upon a time, there was an heir, the sole heir, of a person who died without a will. Let's say in Quebec. And that person, being not a resident of Quebec, for, let's say, taxation reasons, preferred to appoint another person as a liquidator, like a Quebec resident person as a liquidator for the estate, so that the estate would be considered a Canadian, a Quebec estate. Yet, there was a trouble, or at least there was a question, because some people, particularly some notaries, were of the opinion that if he was the only heir of the deceased person and if there is no will, then he could not appoint anybody else as a liquidator. And for that matter, they cited the Article 784 of the Civil Code of Quebec. No one is bound to accept the office of the liquidator, executor of a succession is the estate, unless he is the sole heir. So the interpretation is that if he is the sole heir, he is bound to accept the office of the liquidator. As you can see, even in such an interpretation, it doesn't say that he could not later step down from the position, resign the office of the liquidator, and appoint somebody else. But the common opinion is that's what this article means, that if you are the sole heir, then you cannot pass the charge of the liquidator, of the office of the liquidator, to somebody else. That's one of the opinion, but as you can understand probably already, with respect, I disagree and I'm of another opinion, and here I'm going to discuss it with you. But please take into account that what I'm discussing is like my take on it, and it doesn't mean that if you bring this opinion to the court, the judge would agree with you. So if you have a particular case like that, of course you need a lawyer to discuss with. We're discussing it here as a theoretical, like an academic problem, sort of. So what do we have to interpret? Because what we're talking about is the interpretation of the Article 784. How can we approach it? Usually the interpretation starts with a comment of the minister. So that was what was the minister saying to the Parliament, to the National Assembly of Quebec, when explaining what is this article about before the Civil Code was accepted. The minister basically said that it is a continuation of the previous law. And the previous law was Civil Code of Lower Canada, Code Civil de Bas Canada, and particularly this Article 910, where, as you can see, there is no exception. It basically says that no one can be compelled to accept the office of the testamentary executor, the liquidator. Back to the Article 784, you see that the rule is repeated here. No one is bound to accept the office of the liquidator. So we can take it as the rule, and the phrase "unless he is the sole heir" as an exception. So far, this is coherent with the explanation given in the Collection de Droit, where it says that yes, the liquidator is obliged to take the office of the liquidator of the estate, and it doesn't say anywhere else that he could not pass it later to somebody. But, and here's where I think, with respect again, the confusion starts. In a very famous legal treatise by Jacques Baron, La liquidation des successions, this renowned author brings an opinion that the Article 784 doesn't give an heir the power to designate somebody else as the liquidator. So, the author continues, he is obliged to take charge as a liquidator without a possibility to delegate this function or to designate a replacement. And again, with respect, I disagree, because at least my reading of the article doesn't make it this strict. It only says that if you're the sole heir, you're bound to accept the office. It doesn't say that you can no longer pass it anywhere else. And the Article 785 specifically says that if there is no will, there is no testamentary provision, the majority of the heirs, and if you're the sole heir, you're definitely the majority of the heirs, may designate the liquidator and provide the mode of his replacement. So, at least my reading of these two articles say that together they provide a very clear legislative regime that if you are the sole heir, you are presumed liquidator, and you are, unless, if you are willing so, you designate somebody else to be the liquidator. Again, we are in the presence of the rule and the exception. And the rules of interpretation are quite clear on that. The rule is interpreted like in a large and liberal manner. The exception is interpreted in a strict manner, meaning that you can interpret like generally and stretch the rule over certain facts, but you cannot stretch the exception. And at least in my view, this interpretation of the Article 784 of the Civil Code of Quebec is a stretch of the exception, not of the rule. Why do I think it's an exception? Because so far we have these two articles, and we can interpret it in a way that there is a rule 785 and the rule 784, as the minister said, that it goes by the previous rule that no person can be compelled to accept the office, but with an exception. But that's so far my opinion. Let's see what the legislator thought about that. To go there, we are reviewing the Journal de Débat, meaning that we can look into the minutes of the discussion of this draft legislation at some point, sometime before, particularly how it was explained to the deputies, to the members of the provincial parliament. And in that document, we clearly see that it was said that it creates an exception who cannot, for the heir, for the sole heir, who cannot refuse the position. But again, that's not what we currently discuss. Yes, it's clear that the sole heir has to accept the position. He's a presumed heir. And there is an explanation why. Because the legislative commission at the time, the representative of it says, it is needed to ensure that at any moment, if there is nobody else, there is always a person who is presumed and taken as a liquidator in order to just shorten the delays. So the sole heir is presumed to have accepted the office if he is the sole heir. Again, it is said clearly that it's an exception, and it is said clearly that the reason for that exception is to make sure that there is always somebody who is the liquidator of the estate. As you can see, nothing in the idea that the sole heir is a presumed liquidator unless he, as the majority, designates another person as a liquidator or provides a mode of his replacement. This does not contradict the legislative logic. Moreover, the legislative Journal de Débat does not, in my respectful opinion, does not support the opinion, because it's a doctrinal opinion, it's not a law, that the sole heir cannot delegate his function. Again, in my view, the combination of these two articles, in the view of the comments of the minister, in the view of the Journal de Débat, on the contrary, it says that the sole heir, being a presumed liquidator, can later designate somebody else as long as there is always somebody as a liquidator for the estate, because that was the purpose of this legislative provision and this exception, according to those who are preparing this law and how it was presented to those who were voting for this law, for this particular article. There is some judicial discussion of this problem, but in the context usually when the sole heir is a minor, because again there is a view that the tutors to the minor can designate the new liquidator on their own, or they need to go to the court for that, and those judicial decisions, they cite some doctrinal sources, but at least in my view, at this point, there is no clear judicial resolution on how we should interpret the Article 784 in the view of the Article 785 and in the view of the legislative intent. So that's the discussion for today. Thank you and have a nice day.